Hello everyone, welcome back to Conquer Learning and welcome to today's video where we are going to continue our Industrial Dispute Act Part 3. My name is Lakshmi Kushwaha and I'm verified educator on an academy. So today we are going to move to the Part 3. In Part 1 and Part 2, we have studied evolution. We have studied the important definitions related to Industrial Dispute Act. In second part, we studied important authorities under this legislation. We have studied that settlement arises in the case of conciliation and award arises in the case of adjudication and arbitration. So today we are going to study that what is the duration when the settlement comes into the operation, or what is the duration for which the award start commencing, or till what period of the time the award remains in the force. Other than this, we are going to study very important thing about strike and lockout, legality and illegality of the strikes and lockout in today's video. So let's start. So in last session, in section number 17, we studied that whatever the award comes from the labor court, industrial tribunal or national tribunal, the award is to be sent to the appropriate government, and the appropriate government within the 30 days publish it in the official gazette. So this was your section number 17. Now we come to the section number 17A, which talks about commencement of award. So when is the award said to be commenced, or when the award is said to be that it is now applicable? So now any award, including an arbitration award, will come into the enforcement or would become applicable on expiry of the 30 days from the date of its publication under the section 17. So this 30 days which we studied in section number 17, that appropriate government within 30 days publish it. So after the expiry of this 30 days of publication, the award becomes enforceable, or award comes into the operation. Right? Now, in case the appropriate government is of the opinion that the award, whatever the award which is given by either by labor court, industrial tribunal, national tribunal, is case in which appropriate government feels that it should not be applicable in interest of the public, maybe because of any of the reason in case of national importance, that is national tribunal is central government feels it, and in this case if the appropriate government feels that in the expedient of the public ground affecting national economy or the social justice, because of any reason, if the appropriate government or the central government feels that applying or enforcing this award may affect the national economy or the social justice, then it will stop. Then it would declare that the award shall not become enforceable on expiry of said 30 days. So after this 30 days, it won't be applicable. Only in case if the appropriate government and the central government feels that in the public grounds or public interest it is not safe, or it is going to affect the national economy or the social justice. This is the case when it won't be applicable or it won't come into the enforcement. But otherwise, after the publication, after the expiry of this 30 days, the commencement of the award starts, or the award becomes enforceable. Clear? Now let's move to the next very important point is, suppose any award has been given by the labor court and industrial tribunal or national tribunal. Now if the appropriate government or the central government in case of the national tribunal, if they want to change this award, they want to change, they want to add something, they want to reject it, or they want to modify this award, the government can do this. The government can do this, but it can be done within the 90 days from the date of publication of award. Within the 90 days from date of publication. So the date on which it was published in the official gazette, So within 90 days of publication, it would be modified, or it can be rejected or modified by the appropriate government or the central government. And once, for whatever changes it has or it is applying, it has to be put forward in front of, before the legislature of the state legislature. Like we have Rajya Sabha and Lok Sabha for the central, for the state we have Vidhan Sabha and Vidhan Parishad, so it has to be put forward before them. So they would be looking after it, and then accordingly the changes can be made. Clear? So the few things that you need to remember is, when does the commencement or when does the award becomes enforceable? After the expiry of the 30 days of publication of the award, and if any modification or rejection has to be made in the award, when it can be done? Within 90 days from the date of publication. Now, third important point is that whenever any award as rejected or modified by the government is laid before the legislature of the state or before the parliament. Now, if the modifications are done earlier, it would become enforceable after the expiry of 30 days. Now, suppose the modifications has made. So, after the modification, it shall become enforceable on expiry of 15 days from the date on which it is so laid. So, after the expiry of 15 days, the date on which such modifications were put forward in front of the legislature, स्टेट लेजिस्लेशन विधानसभा और पार्लियामेंट के सामने जब रखा गया था, फ्रॉम दैट डे आफ्टर द एक्सपायरी ऑफ 15 days. So if it was 1st of January when it was, the award was changed, modified, and it was laid before the you can say parliament, in front of the parliament. So after the expiry of 15 days, so from 1 to 15th means after the 15th, on 16th, so on 16th, the award would become enforceable. Very, very important points. The questions are framed from here that you need to remember. Next important section is payment of full wages of workmen pending proceedings in the high courts. Now, suppose some proceedings related to labor court, industrial tribunal, national tribunal are being in the process. So, what about or the proceedings is going on? What if such proceedings or such awards, what if such employer prefers any proceeding against such award in high court or supreme court? Now what happens, the employer has, there was some proceeding going on in the labor court, tribunal and national tribunal. Now this labor court, industrial tribunal, national tribunal, they gave the award, they gave certain award, and now this award has been given or taken up to high court or supreme court by the employer. So during the time period during which the proceedings are going on in high court and supreme court, the workman will be getting his full wages. So employer shall be liable to pay such workmen during the period of pendency of such proceeding in the high court or supreme court, full wages last drawn by him. Whatever wages he was drawing, same wages would be given to him, inclusive of any maintenance allowance admissible to him under any rule. If workman has not been employed in any establishment during such period, an affidavit by the workman had to be filed to effect in such court. First thing, the complete full wages has to be given. Second thing, if he was not working with any employment, an affidavit has to be given. Third thing, if the person is getting the remuneration on any other place, or he has been working in any other place, in that case also it does not have to give the wages. So provided where it is proved that satisfaction of high court or supreme court, the workman has been employed and have been receiving adequate remuneration during such period, the court shall order that no wages. So no wages would be given when? No wages would be made compulsory only when he is getting an adequate remuneration or he is working somewhere else. Very, very important. So yes, workman is liable to get full wages if the proceedings are pending towards higher courts or the supreme court. Now, whatever the settlements or the awards, settlements through the conciliation process and awards through the adjudication and arbitration process. So whatever the settlement and awards are coming through conciliation and the arbitration and adjudication process, they are binding. Settlement are signed by both the parties. So once they are signed, they have to be binding on both the parties. Awards again binding in nature, though it is not signed by the party, but it is binding in nature. So now it would be binding on whom? Who people would be following this awards or the settlement. A settlement arrived by the agreement between the employer and workmen otherwise than in course of conciliation proceeding shall be binding on the parties to the agreement. So whoever party is, employee and employer, or whoever the party have signed that particular agreement, will be on them the agreement or the settlement would be binding. If it is the arbitration award, in case of arbitration award, it would be enforceable, it would become enforceable and it would be binding on the parties which have signed the agreement. Clear? Now, in case of the award which comes in case of labor court, tribunal or national tribunal, it will become enforceable as per the section number 17A, and it will be binding on all the parties who were affected by industrial dispute. So employee and employer, employees basically, all other parties summoned to appear in proceedings at parties to dispute, unless the board, arbitrator, labor court, tribunal or national tribunal, as case may be, record the opinion, they were summoned. Summoned in the sense, जो witness के लिए आए थे और जो वहां पे present हुए थे इस dispute के दौरान, they on them also the you can say the award would be binding. Clear? So that is your section number 18. Next, very important, period of operation of settlement and the award. So for what period the settlement would be binding or it would be in operation, and what period the award would be in operation. So any of the settlement which come into the operation, any of the settlement will come into the operation. So when does the settlement comes? When the employee and the employer through the conciliation process, they sign the agreement. So on the date they are signing the agreement, as per the agreement, whatever date they have mentioned in the agreement, they agreed on agreement, they signed on the agreement, and there must be a date mentioned in the agreement on which the agreement would be enforceable. So the date which is mentioned, on that date the settlement would become enforceable. Now in case they have not mentioned this date, so on the date it was signed, so the date on which it was signed, on that date the memorandum or the settlement will be coming into force or it would be into the operation. मतलब क्या, या तो फिर जो डेट उसके अंदर मेंशन की गई है एग्रीमेंट में, वो डेट के अंदर में वो ऑपरेशन में आएगी. अदरवाइज अगर डेट कोई मेंशन नहीं की गई है तो जिस दिन वो एग्रीमेंट साइन हुआ है उस दिन से वो ऑपरेशन में आ जाएगा. नाउ this remains for what duration? So first case is whatever time period. Suppose in agreement it is written that it would be applicable for 1 year. So whatever duration it is mentioned in the agreement, the settlement would be in operation. Second case, if they have not mentioned any such, date or any such number of the days till when the agreement would be in operation or the settlement would be operation, then for at least minimum 6 months the settlement would be in operation. अगर नहीं मेंशन है कोई डेट कि वो 1 साल के लिए, 2 साल के लिए, for if they have not mentioned any duration for 1 year, 2 years, 6 months, they have not mentioned any of the duration for what period this settlement would be applicable. In that case, the minimum time period for which the settlement would be there is 6 months. After completing this 6 months, it will continue in the operation. It will continue to be continuous in the operation till any of the two parties give 2-month notification for removing, or for, you can say, they are now expiring it, or you are terminating it. They are terminating the agreement. So let me explain you this in the simpler one. Suppose I am the person employee and there is the person employer. We signed an agreement. So agreement has two cases. There is no date. Suppose a date is mentioned. Let's take it as first date, that it will come to in, it will be applicable from 1st of Jan. So from the 1st of Jan, my agreement will be in operation. And in this agreement only, it is mentioned that it would be applicable for 1 year duration. So settlement would be in operation for complete 1 year. Now suppose such date is not mentioned in the agreement. So the date, so suppose this was signed on 31st of December. Okay, so 31st of December. So it was signed on 31st of December. So it would become an enforceable on 31st December, and neither they have mentioned the duration. So the minimum 6 months duration the settlement would be in operation. Now when this would come to an end, till the both the parties, any of these two parties, give 2 months notification stating that they want to terminate this agreement. So after the expiry of this 2 months, this was in operation for 6 months. Now both of them want to terminate it. So any of the party giving the notification of at least 2 months that they want to terminate it, after the expiry of this 2 months, the settlement would be terminated. So that is the for applicable for the settlement. So when would it become enforceable? On the date which has been given in the agreement. If not such date, so on which it was signed. What duration? The duration which is mentioned in the agreement. If not, duration is not mentioned, minimum 6 months, and it will continue till one of the party gives 2 months notice stating that they want to terminate it. Once this 2 months duration expires, then the settlement is terminated. Now let's move to your award. Now award comes in the case of industrial tribunal, labor court and national tribunal. So any of the award will remain in the operation for the period of the 1 year. How many? Period from the of the 1 year. From which date? From the date on which the award becomes enforceable. And when does award becomes enforceable? After the expiry of 30 days of publication. So after that it becomes enforceable, and till 1 year it would be in the application. Provided this 1 year can be extended by the appropriate government to maximum 3 years. So one period of 1 year can be extended to 3 years. So 3 years maximum particular award can be into the operations. Operations मतलब कब तक लागू होगा? When, till when, what period of the time it would be applicable. Very important section. Questions are framed from this. Now section number 22, very important, prohibition of strikes and lockout. Under Public Utility Services or under Industrial Dispute Act, the prohibitions of strikes, or there is a prohibition on strikes and lockout for the public utility services. Like you cannot go on the strike without giving the notices. Now it applies both for the employee and employer. Employees does the strikes, employer does the lockout. Now how does this take place, or what are the conditions? Employees prohibition of strikes in the public utility services. Any of the employee in the industry or in the public utility services will not go on the strike in breach of contract, means breaking the contract. They cannot, breaking in the contract, they won't go on the strike in such a way that it is affecting their contract, without giving a employer a notice of strike within the 6 weeks before the striking. So before the 6 weeks, so 1, 2, 3, 4, 5, 6, 7 days in a week. So we have 6 weeks. So we will be having 42 days. Okay, so 42 days. Within 42 days, within these 6 weeks, rather I would take it as 6 weeks. Within the 6 weeks, the employees have to give the notice to the employer that they are going on the strike. Clear? 6 weeks. Now, on any day whenever they are giving the notice, suppose they gave the notice on 1st of Jan that in coming next 4 weeks or next 6 weeks they are going to go on the strike. So from 1st of Jan till 14th of Jan, so within 14 days of such notice they cannot go on strike. So they cannot go on strike. First is they cannot go on strike without giving an employer notice of the strike within 6 weeks before striking. Second, within 14 days. So from 1st to 14 days, this is called as cooling off period. Within this 14 days, they cannot go on the strike before the expiry of date of strike specified, and whatever date they are mentioning in the notice that we will be going on the strike on suppose 2nd Feb. So before the expiry, you cannot go on 28th January. No, not at all. Until and unless the 2nd Feb get expired, you cannot go on the strike. During the pendency of any conciliation proceedings and 7 days after the conclusion of such proceeding. So please remember the words as it is. During whenever the proceeding is pending with the conciliation and 7 days after the conclusion of such proceeding, the strike cannot be done. Similarly, all conditions are same in the case of the lockout. Employer cannot carry out the lockout in any of the public utility services without giving a notice of lockout within 6 weeks before the lockout, within 14 days of giving such notice. So again, this is the cooling off period, before the expiry of date of lockout specified, and during the pendency of any conciliation proceeding 7 days after the conclusion of such proceedings. Very, very important. The questions are framed n number of the times from this particular section. Now, there are few conditions. Now, suppose there is already strike going on in particular industry or public utility services. So the strike is going on. In this case, the employer don't have to give the notice for lockout. If already the strike is going on, if already the strike is existing, the employer don't have to give any notice for lockout. Similarly, if any lockout is being done by the employer, in that case, the employee don't have to give any kind of notice for the strike if lockout is already in existence. Second important point, on any day when the employer receives the notice from the employee that they are going to go on the strike, employer within 5 days will report to the appropriate government or to such authority as that government may be prescribed. So it would be informing to government as well that there is a strike which is going to happen. Clear? So that is your section number 22, which talks about prohibition of strikes and lockout under public utility services, especially for public utility services. Next comes your section number 23, general prohibition of strikes and lockout. This applies to your public utility services and non-public utility services. Okay, public utility and non-public utility services. No workman who is employed in any industrial establishment shall go on strike in breach of contract, and no employer of such workmen shall declare a lockout. Applies to both, that no any of the industrial establishment, no, neither employee nor the employer will go on strike or lockout, will do the lockout. In what case? If during the pendency of conciliation proceeding before a board, so conciliation board ke paas mein your proceeding, your case is going or your proceeding is pending with the board of conciliation, in that case you cannot go on the strike and 7 days after the conclusion of such proceeding. You cannot go after the conclusion of 7 days after the conclusion of such proceedings. You cannot go on the strike or lockout during the pendency of proceeding before the labor court, tribunal or national tribunal, and 2 months after the conclusion of proceeding. So in case of labor court, tribunal or national tribunal, 2 months after. During the pendency of arbitration proceeding before the arbitrator, 2 months after the conclusion of such proceeding. So here also 2 months, here also 2 months. And during the period in which the settlement or the award is in operation in respect to any of the matter covered by settlement of award. So any of the settlement or the award is in operation during that period of the time also. कोई भी award आया था labor court से, or if there has been any kind of settlement done during that phase, you cannot go on strike or you cannot do the lockout. Very important, section number 22 and section number 23. Next section is section number 24, which talks about illegal strikes and illegal lockout. If any of the employee breaks the provisions of section number 22 and section number 23, means he is not giving the notice, he is going on the strike within the 14 days, he is going on the strike during the conciliation proceeding, he is going on the strike during the arbitration proceeding, in that case such strike would be called as illegal and lockout would be called as illegal lockout. If it is against or it is contravening the provisions of section number 22 and 23. A strike or lockout shall be illegal if it is commenced or declared in contravention of section number 22 or section number 23. Strike or lockout shall not be deemed to be illegal. Now, in which case the strike or lockout will not be considered as illegal? Suppose the employees went on the strike without giving a notice to the employer. So, they did not give the notice. So, this is an illegal strike. So, this is an illegal. If the employer does a lockout against this illegal strike without giving the notice or contravening the provisions of section 22-23, then it won't be considered as illegal lockout. When the lockout is done against illegal strike, it is not illegal lockout, and if the strike is done against illegal lockout, it is not the illegal strike. It would be considered as legal. When a strike or lockout is in pursuance of industrial dispute, has already commenced and is in existence at the time of reference of the dispute to board, arbitrator, labor court, tribunal or the national tribunal. Another point here is, if suppose any strike is already going on, the strike or lockout is already going on. Now the strike and lockout is going on, and during the strike and lockout some of the proceedings started with the labor court, tribunal or national tribunal. So it was already in existence. So you cannot declare it. As per the section number 23, during the pendency of proceeding, you cannot go on the strike. But what if the strike is already in existence? If it was already in existence and then proceeding started, then it won't be considered as illegal. Second, a lockout declared in consequence of illegal strike or a strike declared against the consequence of illegal lockout won't be considered as an illegal. Section number 25, very important, prohibition of financial aid to illegal strikes and the lockout. No person shall knowingly expend or apply any money in direct furtherance or support of any illegal strike or lockout. किसी कोई फाइनेंशियल सपोर्ट नहीं देंगे इलीगल स्ट्राइक्स के लिए और इलीगल लॉकआउट के लिए. That was your strikes and lockout. I hope you understood. If you have doubt, you can ask me later on. Now we would be moving to chapter number 5A, very important, which talks about the provisions related to layoff, retrenchment and closure. Clear? So the Industrial Dispute Amendment Act 1953 prescribed the conditions under which the worker might be laid off and retrenched, and the compensation to be paid to laid off and the retrenched workmen, and this was introduced under the chapter 5A. So it was the Amendment Act of 1953. Chapter 5A was added to the Industrial Dispute Act 1947. So section number 25A, application of section 25C to 25E means what? This chapter 5A is applicable where? This chapter 5A will be applicable, or from the section 25C to 25E will be applicable or not applicable to the industrial establishment in which less than 50 workmen on an average per day have been employed in the preceding calendar month. It is of seasonal character in which work is performed only intermediately. The decision of the appropriate government in case of the whether it is intermediate, whether it is seasonal character or not, it would be the final decision of appropriate government. Means appropriate government would be deciding whether the industry is of seasonal character or not. So where it is not applicable, it is not applicable in industrial establishment where there are less than 50 workmen working on an average per working day. Otherwise, it is applicable everywhere. Section number 25B, continuous service. So when we give the layoff compensation, we give the retrenchment compensation, we give the closure compensation, then a continuous service is to be counted whether the person is in continuous service or not. So what is the continuous service? Any person is said to be in the continuous service if he has been working uninterruptedly for the period of 1 year or whatever the said period is given by the government. A workman is said to be in continuous service for a period if he is for that period in an uninterrupted, including, so uninterrupted matlab break nahi hai, but it includes sickness. You have taken the leave because of sickness. You have faced an accident and disabled. Because of that, you have taken the leave. You were on paid leaves or authorized leave. In this case, it won't be. You were on maternity leave. So this won't be considered as break. Or if you were laid off, it won't be considered as. And if it was the legal lockout or legal strike, it won't be considered as break. It is all considered as working days. So including sickness or authorized leave or an accident or a strike which is not illegal, or a lockout or a cessation of work which is not due in any fault on the part of the workman, laid off under the agreement on the leaveful wages. I have explained you all of this, and he has been absent due to temporary disablement caused by the accident arising out of an in course of his employment. So all these reasons are not for the break. They all are considered as uninterrupted service. Clear? Now let's study what is the continuous service. So usually the continuous service is taken as 1 year starting from the calendar month or calendar day 1st of January to 31st of December. So this is the calendar year, and the continuous time period is considered as duration of 1 year. A person completing 240 days in this completely 240 days in complete 1 year. So that person is said to be an continuous. This is the average 1 year. This is the normal calculation. Now in case everyone is joining on 1st of Jan is not important. So suppose someone is joining, date of joining is, let's say it as 29th of Feb. What is 29th of Feb? So it is not exactly 1 year, but suppose from 29th of Feb till 31st of December, if the person who is employed above the ground, has worked for around 240 days. How many days? 240 days from 29th Feb till 31st December, he has completed 240 days. Even though he didn't join on 1st of Jan, but he was able to complete 240 days, then he is said to be in continuous service. This is for above the ground. For below the ground, if the person has completed 190 days, how many? From 29th Feb to 31st December, if he has completed 190 days, he is said to be in the continuous service. This is in the case of 1 year calculation. Means the person has not joined even on the 1st of January. On paper, on the calendar, it's not appearing as 1 year. He joined on 29th February. So it's not complete 12 months. But in calculation, while you are giving the wages, while you are giving the compensation, this would be considered as 1 year because he has completed 240 days above the ground and 190 days below the ground. Now, in case of 6 months, if it is to count the 6 months, continuous period of the 6 months. So, above the ground, if the person has completed 120 days in the duration of 6 months, it would be considered as the continuous service. And below the ground, if he has completed 95 days, it would be considered as the continuous work or the service of the 6 month. Clear? So continuous service where a workman is not in continuous of 1 year, or this 6 months is like someone has completed 4.5 years, right? So how would you give the compensation, or how would you give the compensation, retrenchment compensation or the layoff compensation? So layoff compensation is 50% of the wages multiplied by the number of the year. So 50% of wages, this year calculation, यहाँ पे year कितने आएंगे? 4.5 or 4. So how would you calculate whether it is complete 4 years? By this way. Whether he has completed 240 days per year. If yes, he has completed 4. Now suppose this is not exactly 6 months. It was somewhere like he completed only 4 months. But during this 4 month, he was able to complete 120 days. 120 दिन उसने काम कर लिया above the ground. Then also he satisfying the condition of 120 days. Then for the calculation purpose, it would be taken as 6 months only. And in case below the ground, it should be 95 days. I hope the explanation for this is clear. So in case of 1 year, 12 months, workmen employed below the ground in mine worked for 190 days is deemed continuous. In case of 1 year, 12 months employed in other cases means above the ground worked for 240 days is deemed continuous. In case of 6 months, work 95 days in case of the workmen employed below the ground in a mine and work for 120 days in other cases. Very, very important definition. Section number 25C. So applicability of this chapter from section number 25C to 25E is not applicable on the place or industrial establishment having less than 50, जो हमने पहले वाले 25 में पढ़ा. So right of workmen laid off for compensation. One person, a workman other than badli or a casual workman. Badli is, so today this person is not available. I called another person to work in place of him just for the 1 day. He is the badli. Casual called for the few hours. So other than this workman, any workman whose name is registered in the muster roll has completed 1 year of continuous service and he has been laid off. In that case, he would be eligible for the compensation of 50% of basic wage plus DA. This is for 1 year. So he would be given 50% of basic plus DA. And any of the workmen cannot be laid off for more than 45 days. So maximum 45 days you can lay off the person. After the 45 days, if you are not able to hire that person, it becomes retrenchment. So 45 days, no compensation shall be payable in respect of any period of layoff after the expiry of 45 days during the period of 12 months. So after this 45 days, they would be getting retrenchment compensation. 45 days, till 45 days, they would be getting layoff. In case they are not hired back, they are retrenched and they get the retrenchment compensation. Section number 25D, duty of the employer to maintain the muster roll of the workman. It is the duty of every employer to maintain a muster roll. Muster roll is register for every entry of provide for making entries therein by workmen who may present themselves to work at the establishment at the appointed time during the normal working hours. So there should be a muster roll where the employees or the workmen makes an entry. They makes an entry that I am present today. They sign and enter into the office. When they leave the office, they again sign it in and out time. So that register has to be maintained by the employer. Now, workman is not entitled to compensation in certain cases, layoff compensation in certain cases. Suppose an employee is there, he has been laid off. Since he has been laid off, he is supposed to get the compensation. But he won't be getting in compensation in case an alternative employment is given to him. काम दूसरा दे दिया ना, he has given alternative employment, so no need of giving the compensation. Second, in case he has given an alternative employment in any other establishment at the distance of radius 5 miles, at the distance of 5 miles, but if he is not presenting himself to work at establishment, काम दिया लेकिन नहीं आए, for at least once in a day, for at least once a day, he is not presenting himself, he won't be given a layoff. He won't be given a compensation. And in case the layoff was the result of because of slowing down or because of the strike किया workmen ने, strike was done by workmen because of which the business was down, as a result the layoff took place. So such layoff won't be eligible for the compensation. So these are the cases when the compensation is not given, when he is refusing to accept any alternative employment in the same establishment from which he has been laid off, or in any other establishment belonging to the same employer. Alternative employment in the same establishment and any other establishment within the radius of 5 miles. Both the cases, if he is not taking it, if he is refusing it, he won't be getting any compensation. He does not present himself for a work at the establishment at the appointed time during the normal working hours, at least for once a day. So he is not presenting himself in the sense बिना बताए absent हो रहे हैं at least for one day, he won't be given any compensation. And in such, laying off is due to the strike or slowing down of the production. Now, conditions precedent for retrenchment. Now, who can be retrenched? And if he is retrenched, what is the compensation? First thing, no workman who has completed 1 year continuous service shall be retrenched until and unless the workman has been given 1 month in notice in writing indicating the reasons of retrenchment. You cannot retrench any of the employee without giving him the notice at least for 1 month in writing if he has completed 1 year continuous service. And after giving the notice, if you are retrenching that person, the workman has to be paid a compensation of 15 days average pay for every completed year. So 15 days average pay for completed year, and notice for the retrenchment has to be given to the appropriate government also. So retrenchment compensation is 15 days of salary drawn for every year service completed. So let's say number of the service is 4 year. So 15 days salary, let's say the salary of the person is 10,000. So 15 days is 5,000. So 5,000 multiplied by 4 years he has completed, 20,000 rupees is supposed to given him as a retrenchment. So that is the section number 25F. Then comes your in case compensation to the workmen in case of the transfer of undertaking. Now suppose there is an employer who has given or has sold the employment to another person, or in case the ownership or the management or whatever, there is a transfer. Now this is going to another person. In this case also the compensation is given to the employee. So suppose these are the employees working in this particular establishment. A was the owner earlier, and now new owner is B. Whatever agreement they have done, within that agreement, the ownership is transferred to B. So now suppose these people are getting affected. Maybe he may not like the place where owner B wants to put up the factory, or maybe he don't want to continue. So his job is getting affected. So this person who is getting affected will get a transfer compensation, and that would be equal to 15 days average pay, exactly that of the retrenchment. But it does not apply if they are not. So even if the transfer is done, but the work of केवल management transfer हुआ है, owner transferation है, the services of this workman is not getting affected in any case. कोई फर्क नहीं पड़ रहा. No need of giving the transfer compensation. Their terms and conditions are not affected. No need of giving the transfer compensation. And in case if the new employer is liable to pay the retrenchment compensation, सपोज ही इज लायबल कि अगर कोई भी अफेक्टेड होता है, किसी की नौकरी जाती है इस ट्रांसफर में, तो इफ द बी इज लायबल टू गिव द रिट्रेंचमेंट कंपनसेशन, तो ए को ट्रांसफर कंपनसेशन देने की जरूरत नहीं है. ही डोंट हैव टू गिव द ट्रांसफर कंपनसेशन इफ बी इज ऑलरेडी लायबल फॉर गिविंग रिट्रेंचमेंट कंपनसेशन. Clear? So the service has not been interrupted by transfer. The terms and condition of service applicable to workmen after such transfer are not in way less favorable to the workman. New employer legally liable to pay the workman in event of the retrenchment. Now next comes closure. We did layoff, we did retrenchment. Next is your closure. Section 25 FF says 60 days notice to be given by an employer if he having an intention to close down the undertaking. You cannot close. आज मन किया अब नहीं करना business बंद. No, you have to give at least 60 days notice to the employees, to the trade union, and even to the appropriate government. This was introduced by the Industrial Dispute Amendment Act 1972. So it was back in 1972, this particular section or this particular provision was introduced. So an employer who intends to close down an undertaking shall serve at least 60 days notice before the date on which the intended closure. A notice in a prescribed manner to the appropriate government has to be sent, stating clearly the reasons why he want to close. But the closure notice does not apply if employing 50 or less workmen. If it is having less than 50 workmen or 50 workmen, it does not have to give 60 days notice. And if an undertaking is set up for construction, building bridges, roads, canals, dams, or other construction work of the project, no need of giving the 60 days notice. Otherwise, you have to give 60 days notice before you close down your undertaking, and the same notice has to be given to the appropriate government as well. And during this closure, the compensation is also to be given to the to the employees. The compensation is exactly same that of section number 25F, that is your retrenchment, that is 15 days average pay of every completed year. So this is in case the closure is done. Now suppose the close down was because of some unavoidable circumstances, those circumstances which was not in the control of the employer. The closure बंद इसलिए हुई जो employer के control में नहीं थी. In that case, he don't have to give this particular compensation. He just can give compensation to be paid to the workman shall not exceed average pay of 3 months. So 3 महीने का average उनको as in compensation दे सकते हैं if the reason for the close down was unavoidable circumstances. Now, what all cases or what all conditions are not considered as unavoidable circumstances? Financial difficulties or financial losses is not unavoidable circumstances. You have to give this compensation. Accumulation or undisposed of stocks nahi hai, extra hai, This is not the unavoidable circumstances. Expiry of period of lease or license, this is not unavoidable circumstances. Undertaking engaged, if it's a mining and in mining operation there is no more minerals available, this is not unavoidable circumstances. Clear? So all in case the compensation is to be given. But if it is a mining operation, compensation won't be given to the employee if the employer is giving an alternative employment or remuneration on the same remuneration which was supposed to be given to him, or his services has not been interrupted. अल्टरनेटिव एम्प्लॉयमेंट दे रहे हैं, माइनिंग में है और दूसरे माइनिंग में भेज रहे हैं, तो ऐसे केस में कंपनसेशन देने की जरूरत नहीं है. So this is the compensation in case of the close down. Now procedure for retrenchment, आप किसी को, so anyone who has completed 1 year continuous service will get 1 month notice and then only would be retrenched. But whom you would be retrenching? Last in first go. So last in first go means, suppose one person was hired on 1st of January and another person was hired on 5th of January. So you would be first retrenching the person who is junior, who joined late. So last in, जो सबसे last में in आया, he would first go. So the employer shall originally retrench the workman who has last person to be employed in that category. So last में जो join किया उसको पहले retrench करेंगे. Section number 25H says re-employment of the retrenched workmen. So suppose you have retrenched someone and over the period of the time again the opening arises for the same position. So you would give an opportunity to the retrenched workmen who are citizen of India to offer themselves for re-employment. आप उनको पहले दोगे. You would hire them and for every opening you would give a prior notice of 10 days for the vacancy. 10 days vacancy and you would give them an opportunity to be rehired. Clear? Now that was the complete discussion on chapter number 5A. We will be moving to chapter number 5B. This is the part of chapter number 5B in next video. I hope you like this session. So give your feedback and if you have any doubts you can ask me. Thank you so much.